Well, hello, beautiful people. I did not expect to see you all here. Day 6 of the trial. You must be all, if you're watching this on replay, you're going, Jesus, this guy's been wearing the same t shirt for the last 3 days. No, it is the same t shirt, but we're doing 3 days in one. So don't you worry about that. Right, so let's see day 6. This is rebuttal time. Rebuttal. Rebuttal. And we have. Oh, actually, yeah. So it's rebuttal and I think closing statements and everything. So I think we've got everything. Let me set it up. So yeah, so we got closings, rebuttal and closings. Share screen. So as we do that, and we're waiting and everything, please make sure you like the video, you subscribe to the channel, consider becoming a blue wench or consider becoming a Erin Taco Club, and let's go. So yeah, here we go. Let's see what this is about.
Jennifer Garcia for the state of Florida.
Catherine Conlon, along with Andrew Parnell, we represent Danielle Redlick, who's present in the courtroom.
Good morning, everyone. We have 8 jurors. This family said that something.
Right, let's go to the rebuttal then. Obviously, because we know that she denies, the judge denies their offering of, you cancelling the trial. Rebuttal, Katie, Nunya. So
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. Good morning, Detective Ware. So during the course of your investigation, at any point in time, did you learn about divorce proceedings?
I did.
And who initiated the divorce proceedings?
Ms. Redlick.
Permission to approach, Your Honor?
Yes, ma'am.
Let the record reflect I'm showing opposing counsel was record identification states AI. I'm who this is record identification states AI. Do you recognize states AI?
I do.
And what is states AI?
It's a court paperwork for dissolution of marriage.
And is this the divorce proceedings that you became aware of during your investigation?
It is.
Your Honor, at this time, the state offers what's been marked for identification states AI into evidence.
Any objection? No objection.
AI will be admitted as the state's next number exhibit.
State Exhibit 64.
Permission to publish, Your Honor?
Yes, ma'am.
welcome everyone. Say hello. It's all good. We're rebutting. Rebutted. I'm glad you all arrived. Thanks, Erin, for bringing everyone over. You, Erin, go back and lick those windows. It's all good. It's all good. Done your job.
And number, let me see if I can books and channels. Under number 16, the durational alimony, can you read starting right here where it says wife?
Wife is without funds with which to fully support herself without this assistance, considering the standard of living established during the marriage, as well as other factors set forth in applicable Florida statutes.
And then down here, on number 20, could you read this to the jury?
Exclusive use of marital home.
And starting right here, can you start reading what words is wife?
Wife needs the exclusive use of this home and the contents thereof, both now and in the future, for herself and the minor children.
So moving to this page, can you tell the jury what was her employment status?
She was unemployed.
And then finally, can you read the jury what the defendant listed as total assets?
It looks like $1,095,500.
I go straight. Please make sure you like the video, guys. Half of you haven't done it.
Now, detective, during your investigation and the course of this investigation, and actually after the investigation was over, did you have an opportunity at any point in time in order to obtain and listen to some jail phone calls which the defendant made?
I did.
And I know that during your direct examination, there was in-depth conversation about you had multiple opportunities to speak with the defendant. Is that correct?
That's correct.
So you know what the defendant sounds like, right?
Yes.
Permission to approach? Showing counsel's mark of identification states G. Mark of identification states G. You recognize states G?
I do.
And how do you recognize states G?
My initials and a date is on top of it.
And on this USB, are there 2 jail phone calls?
Yes, there are.
And did you have an opportunity to review these jail phone calls prior to coming to court today?
I did.
And are these jail phone calls, is it the defendant's voice on those jail phone calls?
It is.
And you recognize that as the defendant's voice?
I do.
On both of those phone calls, correct?
Yes, on both.
Now, detective, and Your Honor, this time I'm going to be asking to publish during this next set of questions what's been admitted as state 6. I'd like to go back to the search of the defendant's home. When the search was being done of the kitchen, were the drawers in the kitchen searched?
Yes, they were.
And were photographs taken and documented of anything of note and value?
Yes, they were.
And when you were looking, you and the CSIs, when you're looking through the kitchen, were you looking for knives in those different drawers?
Yes, we were.
So first, let's talk about the drawers in the island, because there was the island where it had the flat cooking top. Did you open any of those drawers?
Some of them, but some of them couldn't be opened.
Some of them couldn't be opened,
No, they were decorative.
so they weren't real drawers.
Correct.
Now, let's move on to, you said that you were looking for knives in the kitchen, is that right?
Yes.
And if you found any knives, did you document the location of the knives in the drawers?
Yes.
And did you find knives in a drawer?
Yes, we did.
And did you find it in one drawer or multiple drawers?
It was one drawer.
Okay, so you looked in all the drawers and you found knives in one drawer, is that correct?
That's correct.
And it was documented with a photo, is that true?
Yes.
Connecting now. And detective, is this the drawer that you located the knives in?
Yes, that's the drawer.
So this is the only drawer in the kitchen that had the knives, correct?
That's correct.
And for the record, this is photo 3528. And then looking at 3529, is that a close-up of that drawer?
Yes, it is.
One moment, Your Honor.
You attended the autopsy of Michael Redlick in this case, is that right?
That's correct.
And you spoke with Dr. Zadovich,
That's correct.
and she was the medical examiner who conducted the autopsy of Michael Redlick.
Yes, that's correct.
And you had a conversation with Dr. Zadovich, didn't you?
Yes,
And she told you that Michael Redlick bled out within 5 to 6 minutes. Is that correct?
that's what I understood.
That he died within 5 to 6 minutes of the stab wound. Is that correct?
That's what I understood.
May I have a moment? Detective Ware, do you know the state of the Redlick's finances, January 2019?
Yes. We, oh, go ahead.
And what was that based off of?
In the investigation, we had pulled some of the finances to see if they were.
Objection, Your Honor, hearsay, that's not evidence.
May I respond?
Here's it. That's your witness, prosecutor. That's your witness. The prosecutor does not want her witness, lead detective, to state how we know their finances. What the fuck is going on? We're discussing it for ages, it seems.
Detective Ware, you were shown the petition for divorce by the state, weren't you?
Yes,
And you mentioned what the assets were,
that's correct.
and that was back in 2018. Is that right?
That's correct.
Thank you. No other questions.
This judge just agrees with this
No, Your Honor.
state on everything. Objects to hearsay from her own witness. Jesus.
Amy Jones.
Amy Jones. Who the hell is Amy Jones? He must have been on there before. Amy Jones. Ah, freaking Nora.
Could you please state your name for the record again today?
Andrian Leonard Jones.
And the other day we were talking about jail phone calls and some jail phone calls that the defendant made. I'd like to continue that conversation. So we mentioned that the defendant made some jail phone calls with a different PIN number. Is that correct?
Yes.
And could you remind the jury, and when you're looking for the different PIN number, how do you go about doing that?
Again, I start with the information given by the requester, law enforcement. I start with the PIN number of the inmate that they're requesting.
We'd be through this.
I write down, I note the phone numbers that were called using that
Also, he's wearing the same top. Miami Dolphins. But we'd also be through this once. What are we going through it again for?
PIN number. And then I search the phone numbers, also having access to the inmate management system, the system that the jail uses. It says where a person is housed, how long they were there. Knowing that, I know which phones they have access to. It says from the time they were there to the time they leave. So then I know all of the calls that were made using that PIN in those dorms. Again, as I search those numbers, if I find calls made to the same number by a different PIN, I check those calls to verify who it is that's making the call, listening for the inmate to self-identify, say their name, answer to their name. And as I find the calls made by the individual whose calls were requested, regardless of the PIN that was used, I include those in the information that I provide to law enforcement.
So the other day, one of the phone calls that we entered in was a phone call to the number of 440-502-9799.
Yes, ma'am.
Okay. And was that the number in which the defendant was calling to using these different PIN numbers?
Yes,
So the one call that we admitted the other day, she used her PIN number, is that correct?
it is.
And then she called that exact same phone number using somebody else's PIN number, right?
That is correct.
And the PIN number that was used, was it 19013783242?
Yes,
And did it belong to a Connie Kent?
it did.
Okay, and then did Connie Kent and the defendant, were they housed in the same unit?
They were.
And so the permission to approach, Your Honor? Showing counsel some identification as states G. And this is mark identification as States G. Do you recognize States G?
I do. This is call information by the inmate requested. When I listened to the calls on here, I verified the calls and I dated and initialed it AJ.
So these are the two. So these are the calls. There's two calls on here. Is that correct?
That is correct.
And these are the two calls in which the defendant made to that number we were just talking to,
Yes,
and they were using that different PIN. Is that correct?
that is correct.
And these calls, these are fair and accurate depictions of those calls.
They are.
And these calls are kept and maintained in the regular course of your business.
They are.
Here at this time, the state offers was mark identification as States G into evidence. Any objection?
We'll renew our pretrial objection to this evidence.
Next number is
State Exhibit 65.
So let's talk about the first phone call. The first phone call, was that made on May 29th, 2019 at 9:18 p.m.?
That is correct.
Just maybe approach before the publication.
On listening to a recording. Members of the jury, you are about to listen to a recording, two recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you listen to and consider the evidence.
So we're going to listen to, once again, that first phone call, May 29th, 2019 at 9:18 p.m.
Yes, ma'am.
For English, press 4 select. Please enter your phone. Please enter the area code and phone number you were called. Please hold. Please wait while your call is being connected. Please hold. Hello, this is a prepaid call from Johnny. This is Connie.
I'm going to pause it right there for just a second. So this is the prompt. We obviously didn't hear Danielle. Is that because it's that different PIN number?
Yes, the person said their name, Connie.
Yes, orange has correction. To accept this call, press 0. To refuse this call, hang up or press 1. To prevent calls from your current balance is $21.95. This call is from a correction facility and is subject to monitoring and recording. Thank you for using Global Telly. Hello? Hey, please. Did that come through here? Yeah. Well, don't worry about it. So can you talk for a minute? Yeah. Okay, right here? Yeah. I'm just going to now. No, I'm home. How's it going? Nice. Visit? Yeah, so far. Yeah. Not back and forth, but. Yeah, did you get in the video? Yeah, a little bit. All right, why don't we try to wanted to kind of like share with somebody stuff. Talk about tampering. They had another supervisor there tampering because there was so much. I need to say there was so much blood, and I was trying to. Anyway, not saying a lot. I was flipping on it, so I used towel. There's anything that I think to be tampering, so that's kind of but it's like could you consider, whoever. But I don't know what happened between then and there. There's some evidence that he gave, but I saw it. It's just something he has effect when he was writing down stuff about when I was talking about before Michael Redlick keeping along with stuff like he just did this like, oh, today Danielle did this. And it's like all this stuff that happened to me, at one point he was such a fucking, it was awful. The point is I tried to get out of the divorce. He dodged the freaking you can serve somebody, And I tried to serve him 3 times. They couldn't get him. They finally, I expected him again to that house, last final serve. I should have just wished God had gone through the divorce. What they're trying to do is get away, get evidence that her. They're trying to make this a non-self-defense. They couldn't motion for non-self-defense, which is horrible. I like that. Yeah, I heard that. I mean, this is, I'm dead in the water all the way around all this stuff. He got so angry because I wanted to get out of the relationship. Because I finally had enough, like, 5, 6 years ago? And then when I finally filed for divorce, it was, hell of it. So today I was so smashed by that because they think before they said it was kind of sad, and should have left, you know, I should have finalized the goddamn divorce and for not leaving here that night, for not leaving here, period. That got so bad. Maybe since his life is gone, I can take some kind of, you know, yeah, which he just did tonight, guys. That's perfect. That just, there's only one off me, but I'm not saying that I didn't have pretty problems. I'm not saying that he's driving me. The last 6 years were awful. You know, I started declining. I tried to focus. I carried the brunt of the emotional shit on my shoulders the first 10 years when he started to deteriorate. How many losses? He had ED, he lost it. And you know what? Over the career, you know, he wasn't successful. That started to kill him. It killed him, like, emotionally. He started, like, resenting me and they didn't want me to leave at the same time. He would treat me badly and not in a loving manner, in a stupid, selfish, sophomore male way that he thought was, you know, I could go on. I tried to explain this with you guys back then. I don't know if it made sense, but long story short, it's like they're leaving me with this, already degraded. I can't see my kids. They never talk about how they got out of school.
Oh, I talked to Teresa on the way yesterday. She probably had to call her back, but,
Well, my lawyer said something today about, somebody trying to do something for your guardianship.
I think she was one of them.
Or I didn't, I don't think. And your testimony didn't use, however, you can't be
Well, she said, well,
honest with it.
did Matt communicate it? The board?
No, and I'm worried about that too. I don't know what he does. Because I know that my lawyer calls him, like, hey, back off. So I don't want to talk to me, or he's just like, you know, shooting shit, he keeps his little nut in his pocket from hand on shit. I don't know. He's washing his hands of it. I have no idea what he's doing. Like, because Teresa isn't going to handle that for free. What I wanted to do is protect my interest, which if he did, great. But if he didn't, I'm eating on that.
Yeah, I'll call tomorrow. Last time I talked to him, he updated me on things, but so Matt was going to come here, but I don't know.
Because anyway, my friend is center worker over there, and I was trying to find out who was over there, and I wanted a conversation. But
I don't know, did I go to do them just to make sure I know what's going on? Did you get your money?
it looks like there's money in there, yeah. Thank you. We had a shakeout under me, and he took money. But,
So you can just go to the store?
no, I'm gonna go order it now. I saw there was money in there. I started looking at it. Yeah, thanks. I don't know what you have to do for that or if that helps, but.
Also, if there's about something I ordered you to look at for.
Oh, wow. Okay, that's perfect. I mean, I feel like, hey, now we're gonna have something in there. No, maybe two ways, maybe. I've been praying on, no, for instance, I've been praying for the wrong thing. This is a conversation of how we, I mean, as far as I know right now, don't ask me how, but we're going to say, I need to know how to handle this, please. I'm trying to, I'm thinking about writing letters, saying stuff, you know, like.
So that morning,
That morning, the day, I Googled how to flipper it, and that was up in the browser. But I can't. I read too much, but,
yeah, I thought I don't think it was you. I saw all that in the motion meeting.
So let's move on to the next call. The next call was on May 30th, 2019, starting at 10:58. Is that correct?
Yes, it is.
And that was that same phone number, that 440-502-9799?
Correct, yes.
So that same number that she had called with her regular PIN, she's now calling with this other PIN.
Correct, yes.
What? Please enter your 12-digit PID number. Please enter the area code and phone number. Please hold. Hello, this is a prepaid call from Mommy, this is Connie, your mama. An inmate at the Orange County Corrections. To accept this call, press 0. To repeat, your current balance is $16.34. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using Global Tele. Hello? and as soon as I think, okay, so, okay, well, just let's get this statement, statement. Yeah, then I'm gonna go back to that conversation with my son. I was to say, look, you're going under oath, and I was like, I said, that conversation, like, and there's still other stuff that if we waited it out or if it's investigated more thoroughly, or questions were asked properly, or if it's the Eric's partner was the first one to tell me, I don't know if this looks like self-defense, you might have to reposition this. He knew everything, and I told my lawyer. If I'm here now, I'm sitting with that, telling them, oh, self-defense, I already told you once ago.
I mean, it's like you either have to decide if you're gonna take this plea, if they're telling you to kill it, or you take your chances with the jury and you can possibly get life, or, I mean, that's a lot to sit on, and I don't know. I know, but I just.
It was self-defense, it was a struggle, and it was what you're saying. You'll see that it's not that big, or you don't merge them in the market. That was more of a.
I know, but I just.
It was self-defense, it was a struggle.
Not the same.
I don't know if this looks like self-defense, you might have to reposition this. He knew everything, and I told my lawyer. And I'm here now, sitting with them, telling them, oh, self-defense, I already told you once ago.
I mean, it's like you either have to decide if you're gonna take this plea, if they're telling you to kill it, or you take your chances with the jury and you can possibly get life, or, I mean, that's a lot to sit on, and I don't know. I know, but I just.
It was self-defense, it was a struggle, and it was what you're saying.
No further questions of this witness, Your Honor. Mr. Cornell?
I don't get the point was.
Jones,
Yes, sir.
time she's been in jail, do you know how many calls she has made?
I don't know that number.
Nothing further, Judge.
Here, Your Honor.
Thank you.
I don't really. We got that in the what do you call it in the direct. I don't understand why they use that with Reba. Though I don't know. We know she used someone else's phone. Cool.
The state, while the defendant may have the burden of going forward with evidence of self-defense, the burden of proving guilt never shifts from the state, and this standard broadly includes the requirement that the state prove that the defendant did not act in self-defense beyond a reasonable doubt. Also, there is no evidence at the time of the incident that the act was committed with a depraved mind. Here, what we have is
I'll skip it. We know.
We're presenting two theories of justifiable use of deadly force. One theory is the theory that applies to being within a dwelling home. The other one applies to being out in the world, everywhere else. On further consideration, I don't know why it makes sense to give both if one is applicable. Squarely on point. The defense had requested both, but now having slept on it and having co-counsel pointed out, I think that it kind of makes this longer than it needs to be and maybe more confusing than it already is.
Mr. Cornell, what are your opinions about that?
I'm not really sure why it would be confusing. It's an accurate statement of the law.
But that particular section is the Castle Doctrine.
Right, I think that-
Not really what we have here, but.
I don't think the jury should be in any scenario where they don't understand the law about her having to retreat or having no duty to retreat. I think an accurate statement of what the law is should be here.
Well, if the defense wants it, I'm certainly not going to argue to take it out, but I think it makes it maybe more confusing. But it's definitely defer to defense on this issue.
Right. So first of all, apologies. There is no. I can't find the opening statements, closing statements. I can't find them. It's not in the playlist I've got. I'm not trudging through loads of different playlists to find them. But we know what they're going to be saying anyway, roughly. But what I do have and normally if it was there I would play it, but it's like I don't even know where it'd be. So what we do have is obviously the unfortunately, Kate, I don't have a verdict. Joking. Right. We got this is why I set up for some reason I didn't know that I didn't have closings until literally 5 minutes ago. So just so you know, I didn't know because I've not looked ahead too much. So I thought actually the closings were the rebuttals, but they weren't. So we're going straight to verdict.
Ms. Redlick is present. My understanding is that we have a verdict, so let's bring in the jury, please.
I know we've not looked at it all. We know that, but I don't know what people. You can't even see the polls. Look, she's really nervous. No, neither did I, to be honest with you. If I'd have known this morning, I would have looked for some, but I only just found out myself. So she's super nervous. I don't know if I can find her guilty though of murder.
Okay, ladies and gentlemen, my understanding is that you have reached a verdict. Is that correct? Yes. Okay, would you please hand the verdict forms to the deputy, please?
Hang on, let me slow it down. I'll slow it down for this verdict.
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, case number 2019 CF 18460, State of Florida versus Danielle Justine Redlick. Verdict as to count 1, we the jury find the defendant not guilty. So say we all. Signed, juror badge number 283, foreperson. Special finding, this page was left blank. Verdict as to count 2, we, the jury, find the defendant guilty of tampering with physical evidence as charged in the information. So say we all. Signed, juror badge number 283, foreperson, dated at Orlando, Orange County, Florida, on the 17th day of June, 2022.
And would you please poll the jury?
Yes, ma'am. Juror badge number 283, are these your true and correct verdicts? Juror badge number 18, are these your true and correct verdicts? Juror badge number 220, are these your true and correct verdicts? Juror badge number 238.
She's just been told that she's been found guilty for tampering. She didn't realise that.
Are these your true and correct verdicts? Juror badge number 356, are these your true and correct verdicts? And juror badge number 5345, are these your true and correct verdicts? Yes, ma'am. Thank you.
Okay. No surprise.
Ladies and gentlemen, I wish to thank you for your time and your consideration of this case. No juror can ever be required to talk about its discussions that occur in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases, and we have recognized for hundreds of years that a jury's deliberations, its discussions, and its votes should remain their private affair as long as they wish it. So the law gives you a unique privilege not to speak about the jury's work. And although you are at liberty to speak with anyone about your deliberations, you are also at liberty not to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And so on behalf of the Chief Judge of the Circuit, Chief Judge Lisa Munyon, I want to thank all of you for the 2 weeks that you have spent with us in serving your civic duty and serving as a juror on this case. Your duties are now discharged and you are excused. Have a wonderful day. Take care. You're welcome, sir. Thank you.
Yeah, I'm with you. I think she's guilty of tampering because she cleaned up. I don't think she's deliberately.
Ms. Redlick, a judgment of acquittal will be entered for you on counts number 1. A judgment adjudicating you guilty is entered on count number 2. State, is there any legal reason we cannot proceed to sentencing today?
Yes, Your Honor, she's entitled to a PSI. And also want a chance for any sort of impact testimony to be offered. So that's why.
Okay. I will ask Mr. Parnell, who's standing. She is entitled to the PSI. Do you wish to waive the PSI and go forward with sentencing, or do you want to have a PSI ordered and I will set sentencing off?
If we end up setting sentencing off, then I would be asking for her release because at this point, she's going to score 16 points. Jury has not made a finding that would allow for the court to sentence her to prison. Her credit at this point is 3.5 years. And I don't want her sitting in jail longer, which would essentially be adding and extending a prison sentence. So if we want to go ahead today, I understand victim impact, they have a right to do that. So if we set it off, then I'd be asking for the court to release her and set the sentencing date in the future.
Mr. Wiggins, state's position?
Or the state would like to explore the possibility of the imposition of an upward departure, and so I don't believe that would be necessary at this time.
Okay, so I will set sentencing off. Let me set sentencing for August 5th at 10 o'clock. And I'll have that set. I think an hour should be sufficient for that. Betsy, can I have a calendar for August? Can we have a calendar for?
Hang on then, let me just look here to see if. I don't think I got the sentencing here. Surprised they put it off though, but here's what it is. I'm just looking.
Any sentencing memoranda that the parties intend to file for the court's consideration need to be filed by July 15th, close of business on that day. Was there a bond on count number 2? Or I believe proof evident presumption great was found on count number 1. What was the bond on count number 2?
I don't know, Your Honor.
I don't. Okay, so the bond on count number 5, she has a bond that's raised to $15,000. That's always been in place.
Judge, may I approach with case law?
Sure.
This is not, this is.
All right, sounds good. All right, so we are adjourned. Everyone have a good day and be safe. I'm not sentencing her today. I'm setting sentencing off for August 5th. She has a bond in place. She can make bond and she will be released. I'm not changing the conditions of her bond. So your motion for me to release her today will be denied. Anything further from the state that I need to take up?
No, Your Honor.
Defense.
Don't think so.
Okay.
We'll write a motion if we need to.
All right, sounds good. All right, so we are adjourned. Everyone have.
Okay. Right, let's go sentencing then. I'm only playing the sentencing as in what she gets. I'm not playing all the impact stuff because I don't think there's a need to. Yeah, she'll be out. She was smiling. She'll be out. She'll be out on bond. I don't know if she was or not, but she will be now. Let's stop that then. Presents. Share screen. There we go.
You stated you did not wish to make a statement, correct? Ms. Redlick, you testified at trial that you killed your husband, and the jury has found you not guilty of that conduct, and I will not sentence you based upon that conduct. You further testified that after you killed him, you were scared and didn't know what to do, and you froze. And the evidence shows that there were over 10 hours where you waited before you called 911 and gave varying stories as to the cause of Mr. Redlick's death. But you stand before me today for your conduct during the time between Mr. Redlick's passing and the 911 call made on the next day. And it is that conduct for which you are going to be sentenced today. According to the crime scene pictures and evidence, blood stains were smeared throughout the home. You used bleach and other cleaners to clean what looked like a horror scene. Crime scene photographs also showed where you left the cleanup towels and a bucket of colored water. The blood pattern expert testified that typically blood patterns could tell a story or explain the circumstances surrounding a homicide crime scene like this, but not so in your case. The expert also testified that as a result of your conduct, it was virtually impossible to determine the exact circumstances surrounding Michael Redlick's death. The scene was tampered with so much so that the blood evidence was of little to no value to determine what happened between the night of January 11th, 2019 and mid-morning, January 12th, 2019. Conduct for which the jury convicted you, tampering with physical evidence, deserves more prison time than you have served. But the law does not allow me to do that, and I will not sentence you to a prison sentence.
Oh,
You have already been adjudicated guilty of count 2, tampering with physical evidence. And so for that conduct, I will sentence you to 364 days in the Orange County Jail with credit for 364 days time served. That's going to be followed by a period of 12 months of probation. You will report to probation by 3 p.m. The office is on the 7th floor beside courtroom 7B. Within the first 30 days, you will sign up for and you will submit to a mental health evaluation and complete the evaluation and any required treatment within 12 months. I will impose court costs, and there is also a public defender lien that should be imposed.
Court cost of $418.
Mr. Parnell and Ms. Conlon, for the public defender lien, what do you feel is an appropriate cost for your services for the trial and the litigation?
Judge, she's been in jail for 3.5 years on this. She needs to spend her time and resources on rebuilding her life and her family. So we'll be asking for the default.
I'll impose a $300 public defender lien for the services that were imposed or that were provided. And as I stated earlier, there are court costs. The clerk will tell you what the total is.
Court cost of $418, state fee of $100, public defender fee of $300, their fee of $50, for a total of $868.
For the $868, you're going to report to the collections court program and set up a payment plan to make those payments. You have 30 days to file a written notice of appeal, or you waive that right. And if you need an attorney to help you with the appeal, let me know and I will appoint one to represent you.
I don't want to interrupt the court, so.
You want to say cost investigation?
No, Your Honor, I wanted to address another matter, but I was trying to not stand in the middle of the court's.
Do you have any questions about your sentence or your appellate? Anything further I can take it from the state?
Yes, Your Honor. I believe that the sentencing order needs to accurately reflect the time served. Not, I mean, so it should be however many days with that many days credit.
It's 1,228.
So she's sentenced to 364 days with credit for 1,228.
I believe that the proper sentence should be she's sentenced to the number of days she served with the credit for that time served. Defense can correct me, but I think that's how the appellate court would expect that's the phrasing of that sentence, especially when probation is following and we have more credit than we have sentence. I think that it should be the proper way to phrase it is she's sentenced for 128.28 and she has 128.28 credit. That's a lawful sentence.
Judge, we agree with that. We want to make sure that in the event that this is argued about in the future, it's abundantly clear that nobody's trying to take away Ms. Redlick's credit, which I understand. And she is in no way affirmatively waiving any credit she has.
So the sentence would be, my concern is I don't want to be sentenced to a sentence greater than the 364 days.
You do not have the discretion to impose a non-state prison sanction at the time of sentencing. So you are not, by sentencing her to what she's already served, imposing a non-state prison sentence. So we can't, I think it has to accurately state that she was sentenced to that number of days and she has credit for that number of days.
I don't quite understand what's going on.
I believe that's the form that the sentencing order should take to accurately conform to.
And see,
This is just my recommendation.
I disagree because the sentence can't be more than a year. I cannot sentence her to a term greater than 365 days. Even though I'm going to give her for the time that she's already served. Because
And that's why you're.
in that case, then she is receiving a prison sentence, even though she's already served the 1,228 days. The sentence is what I'm announcing.
I have given my recommendation. I respect the court's reading, and it may be a bit academic at this point, but that's just my recommendation. What I believe the form it should take. But I will sit down and allow the.
Something you wanted to say. That's how the sentence will be imposed. She's being sentenced to 364 days. She has already served 1,208 days incarceration. Anything else I need to take up, Mr. Wiggins? Ms. Garcia?
No, Your Honor.
Ms. Conlon? Mr. Parnell?
In the event that she does seek to relocate while she is serving the probation sentence, does the court have any objection at this time to her transferring probation either out of county or out of state?
Out of state, it would require an additional $100 each.
And the administration that comes with her endorsement and her assessment, the court has any, I guess, stance on that at this time? Because I think we would have to come back to you later on. And so we just want to put that.
As far as it relates to transferring probation out of county, the court has no objection to doing that. Still, they'll need to report. For probation transfer out of state, that's going to be an additional $100 for an administrative fee for that. So if you do decide, then that's an additional.
$100.
is that $100 going to be payable? Or do I need to post it today?
It's due immediately when she makes the request. We can't really collect it if she doesn't have a plan right now. But as soon as she makes the request, we can submit it.
And so she just paid that through the.
Yeah, she'll pay that through Department of Corrections.
Oh, she'll pay it through DOC. Okay.
I think this judge isn't very good.
Do you know for certain right now whether your plans are leaning more toward leaving the state? Probably not. Probably not. Okay. Well, then let me do it like this. I have no objection to you transferring your probation out of state. The $100 would be due. And obviously, I have no issue with you transferring your probation within state to another county. But do understand that
What the f?
can I impose it? And if she never decides within those 12 months to go, that's just something she doesn't have to pay.
I mean, I don't think you need to order it on probation orders. It's an administrative fee that Department charges. It's kind of outside of what.
So I don't have to deal with that.
You have to-
I just have to announce or let them know.
We have to announce to make her aware of it. If she wants to do it, she has to. You don't have to.
So there. You just know now that you would have to pay that money if you do decide to travel out or transfer out of state. Anything else?
That's all for right now, Mayor. Thank you.
Were we also hearing the motion for return of property?
That's already scheduled and docketed for, I think, September, or someday in September, which is run after the appellate process. And so we already have a court date for there. I think it would take a little bit of time to get organized and everything. So I'm prepared to do all that. We need to bump it up. Certainly ask for it. From the date.
Day that it's done, I have a 3-week trial period beginning that week. No, beginning the 15th.
I believe the 16th, Judge.
There will be some time during the hearing.
Yeah, she's got makeup on, definitely. Look. Yeah, she's got makeup on. She's very pretty. You've got to give her that. She's very pretty. She has got makeup on. But you could tell she's pretty even without makeup, to be fair. There's nothing to hear. There's nothing to hear. They're muted. They're muted, Nunia. There's nothing to hear. So she looks very good, very good, yeah. So she got 1 year probation, if I understand that right. So yeah, 1 year probation. I thought she was pretty throughout the trial, to be honest with you. But obviously she's even prettier now that she's got makeup and everything like that on. So I'm not really, don't really get. I think the judges are a little bit. I've not liked this judge. In the last day, I think she's very pro prosecution. I think she should have let in some stuff that she didn't. Yeah, the grey, I didn't mind the grey. I thought grey was quite nice to me. So, but no, I think she's more attractive now, if I'm being honest. But yeah, a year probation, but it doesn't make sense to me. She's done a year. The punishment is 364 days, but she's done 3.5. She's done 1,200 days or whatever it is. So why she got probation? I think Nunia's right. Why she got probation then? But unless probation is part of something. But what happens if she breaks probation? She's still got 2.5 years credit. So I don't really know. I don't even think the judge knows what the hell she's talking about. Evidently, I don't know how she's a judge. She's not someone that fills me with any kind of confidence, to be quite honest. But anyway, that's the end of it. We've done it. We've come to the end. You know, you're gonna let your greys show now. Yeah, why not? I've got greys coming through. Some greys up here as well. They're coming with salt and pepper, let's say, don't they? That's a slog. This was a slog. I think it was ups and downs. I generally think that this trial was the correct verdict. I don't think that she should have been guilty of murder, but I do think she should have been guilty of what she was, tampering. And I don't think she meant to tamper with it. I think she panicked. But Katie's right, another trial done. Absolutely. We've got Matt Moore tomorrow. Anyone's around, normal time. Matt Moore tomorrow, and then Monday, I'm excited. It's like a kid at Christmas. We've got the Carriga quadruple murder trial. So if you're around for that, that's going to start at 12 o'clock Eastern. So for the show with this trial. No worries. In a way, it's one of those things where, how can I say it? Some people know the result already, some people don't, so it's hard. So when we do the Carriga one, I'll try to explain this a bit better today. That's our priority, right? But if there's a trial that comes up, for instance, say Alex Baldwin, for example, just example, we can still do Alex Baldwin, but it would mean maybe streaming it beforehand, like a day behind or something. We could do it a day behind. So that means then we can fit it in to me somehow. So because when there's a lunch break in the main trial, we can stream an hour there. So I can fit stuff in. So yeah, so we can do that as well for the trials. But the main one will be the Carriga trial. I think she's planning to. Yeah, I think so. I think so. I do think she was battered. So yeah. Second trial, little at a time. Yeah, I'm not going to do it throughout it all because it'll get too much, So it'll just be for specific trials. Do you know what I mean? Because we'll wear ourselves out. Do you know what I mean? We will. I'll wear myself out, and I don't want that. So, I honestly, throughout December, we will not be doing the second trial. It'll just be this, and then I'm not doing Sarah Boone. I don't think Sarah Boone is. I think going to be totally a waste of time because I know she's innocent unless proven guilty, but she's proven herself guilty already in my mind. So I think it's a complete waste of time. So I think we can watch highlights on that rather than watching it properly. Normally, if you have a probation revoked, you do the remainder of your time. She has no time. So in a way, complete waste of time then, yeah. Because she's gonna. This is complete waste of time. Jesus. Anyway, right. I need a piss. So with that, let's finish this year. Hopefully see somebody tomorrow, and hopefully see everybody on Monday at least. So with that, guys, sorry, Lily, I know you're still writing. I appreciate you, but I have to go. I need to go to the toilet. So love you all. Please, please, please make sure you've liked the video. Please, 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 free Zachariah Anderson. And yeah, you're right, Katie. And yes, you're right, Linnea. So with that, guys, love you all. Thank you very much. Take your time. See you later. End stream. Love you all. Ta-ra now. Take care.